Microphone check, mic check 1, 2. Good morning, everyone. We'll be getting started here shortly. As a kind reminder for those in the room, if you are registered to speak at the microphone today, please make sure that the light is on before you begin speaking, and please make sure that you turn off the microphone before you leave the podium. For those presenting with any graphics or panels, the camera angle you can see directly on the podium, which will be broadcasted publicly. So if you would like for both commissioners and the public to see, you can arrange your media as you wish based off of what you see here on the computer.
Let's try this again. All right. Good morning and welcome to the May 1st, 2025 meeting of the Texas Commission on Environmental Quality. It is 9:34 a.m. I'm joined by my colleagues, Bobby Janeka and Katarina Gonzalez, our General Counsel, Mary Smith, and our Public Interest Counsel, Garrett Arthur. For each item that argument or discussion is allowed, we'll inform the parties and the public of time limits for their discussion. Registration closed at 9:30, but if you'd like to address the commission on a particular item, please either visit our registration table, or if you're here in person, or if you're on the webinar, please email agenda@tcaq.texas.gov with your name, affiliation, and the item that you would like to comment on. We will do our absolute best to accommodate that request. For those making presentations, please wait to begin your presentation until I have asked you to begin speaking. And please check to make sure your line is unmuted before proceeding. All right, let's get this started. Mary, the first item, please.
Item number 1 is the consideration of the ALJ supplemental proposal for decision and proposed order concerning the application of HK Real Estate Development LLC for TIPD's permit number WQ00161-50001. The order of presentation will be the applicant, followed by the protestant, the ED, and then OPIC. Each party will have 5 minutes of oral argument time, and the applicant may reserve time for rebuttal as it bears the burden of proof on this application. And so we'll begin with Ms. Helen Gilbert for the applicant.
Good morning.
Good morning, Chairwoman, Commissioners, General Counsel. I'm Helen Gilbert on behalf of applicant HK Real Estate Development LLC. I'm in the very unusual position this morning of having to disagree with the executive director and the ALJs. Unfortunately, they just got it wrong in this case. Prior to the chairwoman's appointment in this case, it came before you on a full summary disposition on all 6 referred issues. The original PFD recommended issuance of the permit, and the executive director agreed. Unfortunately, in the last year, both the ED and the ALJs changed their mind, changed their positions, and these new positions deviate significantly with your prior precedent, with the Texas Water Code, and with case law. In reversing their positions, the ED had to ignore peer-reviewed modeling data that characterized the discharge route from multiple agencies, including the San Antonio River Authority, whose jurisdiction includes the watershed in this area, specifically the San Antonio River. It included data from FEMA, data from NRCS, data from TxDOT. They rejected highly sophisticated aerial imagery, LiDAR technology, showing characteristics of Sandpit Creek. We were explicitly directed to analyze that in the remand order. This data showed a hydraulic and hydrologic connection between Sandpit Creek and the San Antonio River. And finally, they disregarded 2 models, 2 Qualtex models. It's important to note these are the only modeling evidence in the record before you, and that was uncontroverted. The entire remand was couched in terms of informing whether the evaluation of the discharge effect on surface water quality was adequate, and the models show that. Instead, you were asked to believe with this PFD that runoff from over 11 miles and 7,200 acres upstream of this site that have been flowing under Highway 181 since at least the 1930s simply disappears. Not only is TxDOT upgraded its culvert, but to a very big one to accommodate this flow, you're asked to simply believe that it disappears. Protestants don't even believe that. As we discussed in length in the briefing, ephemeral streams sometimes have imperceptible flow, sometimes bed and banks don't appear to the naked eye. That doesn't mean they're not streams. That doesn't mean they're not water in the state. It is uncontroverted that the discharge goes into water in the state. That's your mandate under 26027. Under Domel versus Georgetown, under your prior precedent of DHJB, once the effluent is discharged into water in the state, it becomes state water, and the state water has a superior right. No further investigation could or need be done. To reject fundamental water law in favor of this new approach espoused by the ED is not just unfair to HK, a deprivation of due process, but it has consequences in many other areas. For example, for the hundreds of discharges into intermittent or ephemeral streams in Texas, will you be revoking those permits that were issued previously? If intermittent streams are no longer water in the state, may water rights diverters divert and impound water in the state without oversight, without water availability analysis, without permitting? Alternatively, if there are a lack of future discharges, what will happen to return flows? Will applicants have to obtain easements for the entire length of the discharge route? That's what the executive director proposes in this case. How far would that go? Would that go to the first numbered segment or all the way to the Gulf? And is staff currently asking applicants to reroute their entire planned discharges around intermittent streams? As you can see, this interpretation is novel, it's new, it would have drastic consequences for the state of Texas. I'd like to reserve the rest of my time to respond to the other parties.
We'll hear from the protestants now.
May I proceed?
Yes, go ahead.
Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Staff, and Executive Director Staff. My name is Bobby Salahi with Graves, Doherty, Heron, and Moody. I represent Fraser LLC in the Fraser family. Joining me online is my co-counsel, Natasha Martin, as well as the Fraser family. Fraser respectfully requests that the Commission adopt the ALJ's proposal for decision, proposed order, findings of fact, and conclusions of law, and deny the permit application. The core issue is the supposed flow from Sandpit River to the from the Sandpit Creek to the San Antonio River, which the applicant claims exists. But there is no flow, there is no connection, none. This was proven in the record. If this permit is granted, my client's land will be inundated. 4 lakes will form, permanently ruining access to 22 acres of their property. There will be no more farming, no more crops, no more hosting weddings and other community events, and no more raising their national champion cattle. Now, let me briefly walk you through our demonstratives. The discharge route in the application and draft permit is to Sandpit Creek, then to the upper San Antonio River in segment number 1911 of the San Antonio River Basin. This description is incorrect. The first image is applicant's exhibit 48 on your right. It shows the impoundment at the end of Sandpit Creek, where the creek terminates. It does not flow to the San Antonio River. All parties, including the applicant, saw this in person at the June 28, 2024 site visit. The next image is applicant's exhibit 56, a 2022 USGS map showing the new discharge route, which first appeared at the hearing, clearly showing Sandpit Creek ending in the impoundment. The ALJs explained this exhibit perfectly in their PFD. Quote, the 2022 USGS map is the one applicant used to depict the revised discharge route as the purple line. Yet, the 2022 USGS map itself shows Sandpit Creek as a blue dotted line that does not extend past the impoundment. Commissioners, the applicant's own exhibit shows Sandpit Creek's absolute termination at the impoundment with no flow to the San Antonio River. The impoundment that you see on your right is where Sandpit Creek ends, and the record is clear on this. USGS maps from 1973, 2019, and 2022 show the creek ends in an impoundment or field, not the river. The maps applicant relied on for connection are nearly 70 and 90 years old. During the June 2024 site visit, the TCEQ staff found no surface connection. The standards implementation team concluded the route in the application is incorrect and the creek ends in a field. Experts from every party visited the site and walked the discharge route. ED witness Mr. Caston and Fraser witness Dr. Jordan Fernandes both noted the lack of channel beyond the impoundment and the uphill path from the impoundment to the river, a physical barrier to connection. It's common knowledge that water does not travel uphill. Applicant's own witness, Mr. Dan Ryan, admitted that water does not flow from the impoundment. I'll note that the impoundment that you see is over 350 yards or 3.5 football fields away from the river. Regarding the discharge route is not adequately characterized in accordance with 309.12. The issue you referred is whether the discharge route is adequately characterized in accordance with 309.12, which applies to plant siting, but the route remains incorrect as described. The applicant did not conduct any soil studies in this application. The absence of a proper soil analysis renders the route improperly characterized under the soil and hydrologic factors of 309.12. Because the route was inadequately characterized, the applicant tried to substitute a new discharge route during the remand, which is over a mile away, without new analysis by the ED. It wasn't just a minor change, it was a major modification that created a new route entirely. That hasn't been evaluated by the agency. It's a bait and switch attempt. This draft permit was based on a discharge route that simply does not exist. An applicant failed to meet their burden here. Regarding water quality, the ALJs again explained this, the inadequacy of the water quality review performed, stating the technical review was performed on an invalid, non-existent discharge route and cannot now be used to extrapolate a technical review of the new discharge route. The ED cannot assess water quality based on this invalid route. Regarding use and enjoyment, the draft permit will create 4 lakes on the Fraser property, destroying over 22 acres currently used for farming, cattle, recreation, and community events. You heard a little bit about waters in the state. An issue here is that it's not waters in the state beyond the impoundment. At that point, the overflow from the impoundment is diffused water, which isn't permitted by the TCEQ, as many witnesses attested to during the hearing. Regarding the DeMel case, here, Sandpit Creek has no carrying capacity, which the water body in DeMel had. Many witnesses testified in detail that the discharge will overflow Sandpit Creek. Evidence showed Sandpit Creek's lack of well-defined bed and banks south of the impoundment, another key difference from that case. Really, Sandpit Creek isn't even a creek past that impoundment. Regarding the ED changing position, the Texas State Board of Pharmacy versus Wilder case of 2014 held that the agency is not bound to follow its decisions in contested case hearings the same way a court is bound by precedent.
That's time.
May I close?
Yes.
This case highlights why public participation matters. This land is the heart of the Fraser's family's legacy and livelihood. The discharge route is invalid. Sandpit Creek does not connect to the San Antonio River. For these reasons, we request that you deny this permit application. Thank you.
Thank you, Mr. Slahi. Do you want to take a second to look at the exhibits, or are y'all good? Well, I'm very short, so I'm going to stand up and make sure I see everything.
Would you like them to move
Yes.
them so that you can see the ED and OPIC?
Yes, please. Thank y'all. Edie?
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, on behalf of the Executive Director, I am Fernando Salazar Martinez of the Environmental Law Division. With me today is Michael Parr of the Environmental Law Division and Deba Dutta and Greg Easley of the Water Quality Division. The Executive Director agrees with the Administrative Law Judge's findings of fact and conclusions of law as referenced in their supplemental proposal for decision on the 3 referred issues. The ALJs found that the draft permit is not adequately protective of water quality, including the protection of surface water, groundwater, and animals in accordance with the applicable regulations, including to Texas surface water quality standards. The proposed discharge route is not adequately characterized in accordance with 30 Texas Administrative Code, Section 309.12, and the draft permit is not protective of the requester's use and enjoyment of its property in accordance with the Texas surface water quality standards. The ALJs determined that the proposed discharge route, as described in HK Real Estate's application, is not accurate because Sandpit Creek does not have a surface water connection to the San Antonio River. Instead, Sandpit Creek terminates in a pond in a field. Because the proposed discharge route does not exist as described in the application, the executive director cannot support issuance of the draft permit. The executive director respectfully recommends that the commission adopt the ALJ supplemental PFD with the inclusion of the executive director's exceptions and deny the application. Thank you, and we're available for questions.
Thank you very much. Any questions right now for the ED? Right, we'd like to hear from OPIC.
Good morning, Chairwoman and Commissioners. For the record, I'm Garrett Arthur, TCEQ Public Interest Counsel. OPIC supports and concurs with the ALJ's recommendation that the application should be denied and the permit should not be issued. Applicant HK Real Estate Development bears the burden of proving each of the remanded issues by preponderance of the evidence. Based on the weight of evidence, applicant has failed to meet its burden of proof on all remanded issues. Therefore, OPIC respectfully recommends denial of the application. In the interim order, the commission asks whether Sandpit Creek flows into the San Antonio River or terminates on protestant's property, as the nature of the water course and where it terminates inform whether the discharge's effect on surface water quality was adequately evaluated. At a June 2024 site visit, ED staff determined there is no surface connection between Sandpit Creek and the San Antonio River. The ALJs echoed this finding by concluding that Sandpit Creek does not flow to the San Antonio River. Applicant's error regarding the discharge route is a problem that affects every other issue in this case. Because of it, none of the three issues can be answered in applicant's favor. Finally, we note the alignment between the ALJs, ED protestant, and OPIC. And to conclude, we respectfully recommend the application be denied.
Thank you, Garrett. Please tell Eli congratulations on the new baby. Thank you. Ms. Gilbert, you technically have 15 seconds for rebuttal, but since we gave Mr. Salahi some extra time, we're going to give you 1 minute.
I appreciate that.
Thank you.
Thank you. I'll try to be fast. Fraser will not be inundated. His land is already almost entirely within the 100-year floodplain. We did not rely on ancient data. We relied on a HEC-RAS model from 2003. It's very recent data. They just ignored it. Mr. Fraser showed himself where flow, in his experience, personal observation, actually left Sandpit Creek and went into the San Antonio River. On the issue of amendment, the allegation here is that one part of one page of the USGS map in the application was wrong. Instead of going to the southwest, it actually goes to the southeast. And protestant's expert actually supports that, not absolute termination. And so we amended that. There is no prohibition in your rules in 281 or 30562 preventing an amendment to the application during the hearing process. That's absolutely not prohibited. That's what we did, and that's what the parties failed to respond to. So there was a minor amendment, and no further notice was triggered by it. The description in the notice, the description in the application, and then the draft permit all stays exactly the same from Sandpit Creek to the San Antonio River. That doesn't change. Thank you.
Ms. Gilbert, was
Yes, ma'am.
the application ever formally amended?
Your Honor, we offered amended maps during rebuttal.
But was it formally amended?
We provided that to the executive director, and the executive director filed a brief, not requested by the ALJ, saying that their position was informed by information obtained and analyzed throughout the entire process, from the application to the final decision, which would be today. They simply didn't look at it. Their explanation was that the reason they didn't provide modeling is because of resources. They provided 3 standards staff members, but no modelers.
Thank you. Mr. Salahi, do you have anything to rebut to that?
Would you like me to rebut to your question to her?
Yes.
Yes, Chairwoman. They did not amend this application. During the hearing process, during the remand hearing, when it was clear that the map in the application and the draft permit route and the application map was incorrect, they showed up during the hearing with a new route that the ED had not done an analysis on. There had not been water quality modeling done on it. There had not been done anything on it because SOA had the jurisdiction over it. So it was not formally amended.
Thank you. ED and OPIC, same question.
During the consistency case hearing process, I don't believe we received a formal amendment request.
Garrett,
Well, Chairman, I would note that I think this type of change to the discharge route, it would be significant and would actually require new notice. So I don't see that a formal amendment was made here.
all right. Thank y'all very much. So I agree with the ALJ's recommendation to deny the issuance of this permit. I believe the record supports the findings that Sandpit Creek does not connect to the San Antonio River. Specifically, the USGS maps in the record show that Sandpit Creek ends in a pond and does not reach the San Antonio River. This was also confirmed by the ED's site visit to the property. The record also supports that the applicant's new proposed discharge route diverges from the route in its application by more than half a mile from the initial route identified in the permit application. I believe that this revision is a significant change to the application, necessitating additional technical review to determine whether water quality standards would be met. As the ED testified, this has not occurred yet. Therefore, I do not believe we can grant this permit. I would adopt the ALJ's proposed order with the changes they recommend in their reply to the exceptions, and I would adopt the ED's response to comments, but only to the extent that they do not conflict with the commission's decision today. I'll stop and ask Bobby and Katerina what they think.
Thank you, Chairwoman. I agree with you, the ALJ, the ED, and OPIC on this decision. I'll note that while it was only a single small map change, the discharge route is a fairly significant one. And thank you, Mr. Arthur, for naming the, in my view, the requirement, the obligation to tell the public of that change in order for this process to be considered by our staff. And given the timing of this in how it precluded our executive director staff from being able to analyze the relative issues we look at, I'm in agreement with the ALJ's position.
Thank you, Bobby. Katerina?
I see it the same way. Thank you.
Thank you. Do I have a motion?
I move that we adopt the ALJ's proposed order attached to their supplemental proposal for decision, as revised by the ALJ's letter regarding exceptions dated March 18th, 2025. Further move that we deny the permit application of HK Development LLC and that we adopt the ED's response to comments to the extent consistent with the commission's decision and final order.
Second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you. Thank you all. Give you a minute to get settled. Item 2.
Item number 2 is the consideration of the application by Carland LLC for new TIPD's permit number WQ0016449001. The parties have been notified that the commissioners will not take oral argument, but may ask questions, and those who have signed in will be noted for the record.
Thank you, Mary. Before us, we have an application for a new TIPD's permit that would discharge up to 250 gallons per day of treated domestic wastewater. For these types of applications, the commission considers a 2-step analysis. First, we determine whether a hearing requester is an affected person. If they are affected hearing requestors, then we consider whether the affected person raised issues in their hearing requests that are referable to our friends at SOA. We received hearing requests on this matter from Terry Bays, Steve Hortzman and John McGill and Ms. Mary McGill. So let's talk about effectiveness. First, regarding effectiveness, which determines who has the right to a hearing, I agree with the ED that the hearing requesters have failed to demonstrate their right to a hearing. To be considered an effective person, a requester must identify a personal justiciable interest that is within the commission's jurisdiction to consider and explain how they will be affected by the application in a manner not common to members of the general public. In this matter, the hearing requesters expressed concern regarding flooding, erosion, and the general location of the facility. And their reply reinforced that these, rather than water quality issues, are at heart of their concern. Erosion, flooding, and facility location are outside of the commission's jurisdiction to consider for this type of application. So I'd find that the hearing requesters failed to identify a personal justiciable interest within the commission's jurisdiction on this matter and deny their hearing requests. I'll stop there and see where my fellow commissioners land on effectiveness.
Thank you, Chairwoman. I agree with you, and I think the reiterating those same views in the reply was instructive for me as well. I'm fine with you.
I see it the same way.
Right, do I have a motion? Oh, I'm sorry. If we agree on the effectiveness, then there are no issues that need to be referred to SOA. So I would grant the permit and adopt the ED's response to comments.
I move that we deny all hearing requests, issue Texas Pollutant Discharge Elimination System Permit Number WQ 0016449001 to Carlin LLC as recommended by the Executive Director, and that we adopt the Executive Director's response to comments.
Second motion.
All those in favor?
Aye.
Aye. Motion passes. All right, Mary, item number 3, please.
Item number 3 is the consideration of the petition filed by OP III ATX Georgetown 220 LP for the creation of Williamson County Municipal Utility District number 60. The parties have been notified that the commissioners will not take oral argument but may ask questions, and those who have signed in will be noted for the record.
Do we have any sign in?
Well, this is a no oral argument. We do have people signed in who are available. We
record.
have, someone from the county and someone for the applicant.
Excellent, thank you. The item before us is a petition to create a municipal utility district with road powers. Williamson County is the sole hearing requestor. For district creation matters, we look only to whether the hearing requester is entitled to a hearing. For this item, TCEQ rules require the commission to consider for governmental entities their statutory authority over or interests in the issues relevant in the application. I note that the county raised its statutory authority related to building and setback and infrastructure planning, which can impact the density of subdivisions and ultimately the financial feasibility of a district. The county also raises drainage issues related to roads. Runoff and drainage are issues that the commission is charged with reviewing in a district creation petition. The county's request also raises concerns about roads within the proposed district connected to the county's broad statutory authority over various aspects of roads. The request for road powers in this application requires the commission to consider the layout of road facilities, the petitioner's cost analysis, and the amount of bonds necessary for the road facilities, and whether they are financially and economically feasible for the district. Therefore, I agree with the ED and the OPIC's recommendations that Williamson County is an affected person and that this matter should be referred to SOA. I would also recommend that this matter be referred to the commission's alternative dispute resolution program to run concurrently with the SOA scheduling process. I'll stop and see what commissioners think.
I'm in agreement.
I have some questions for Williamson County.
Excellent. Is Williamson County signed in and ready to answer questions? Yes, ma'am.
Good morning.
Morning.
I'm Sarah Labashowski from Bickerstaff Heap Delgado Acosta.
The proposed MUD, if granted, would still have to go through your process for plating and road construction and meet the standards required by the county, correct?
I believe so. Yes, I mean, every position that the county has stated is in its November 19th, 2024 letter that was submitted to the TCEQ. And that involves the authority over various functions, including transportation, services, health and safety, as well as conveyance of road improvements, traditional road powers, and the like. So the county's position, it was set forth in its letter to the TCEQ on November 19th.
Okay, I understand, but my question is specifically more, this creation, the county still has to, your arguing is partially based on road powers, that you're an affected person, but doesn't the county still have to approve the road construction and the specifications even outside of this SOA process?
To be honest with you, I'm not entirely sure.
If there's someone else we should consider, then I would recommend that we continue this to the next agenda and have someone that can answer the questions.
That would be preferable.
Okay. Bobby, do you have any objections to that?
I don't object.
Edie?
Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. I'm Justin Tack, Water Supply Division. ED doesn't object.
Do I need a motion for this? I'd like a motion to continue this to the May 22nd agenda.
I make the motion.
Yeah.
No, I move that we continue this to the May 22nd agenda.
Second.
All those in favor say aye.
Aye.
Will you please
Thank you.
come prepared for the next hearing?
Yes, absolutely. Thank you very much. I appreciate it.
Thank you. Item number 4. Good morning.
Item number 4 is the consideration of the adoption of an amendment without renewal of the statewide multi-sector general permit number TXR 050000, authorizing stormwater discharges by certain types of industrial activities. And the executive director is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. On behalf of the Executive Director, I am Hannah Kobos, representing the Water Quality Division. With me today is also Rebecca Villalba with the Water Quality Division and Cole Malley from the Environmental Law Division. Staff requests adoption of an amendment without renewal of Texas Pollutant Discharge Elimination System General Permit TXR 050,000, known as the Multi-Sector General Permit, or MSGP, which authorizes stormwater discharges from facilities associated with industrial activities into surface water in the state. The current permit expires on August 14th of 2026. The purpose of the amendment to the MSGP is to implement the following legislation. House Bill 2771 from the 86th regular legislative session. This bill initiated the transfer of state and federal regulatory authority from EPA and the Railroad Commission for discharges associated with crude oil and natural gas exploration, development, and production facilities. The MSGP is being amended to expand permit applicability to include non-exempt stormwater discharges into surface water in the state from oil and gas activities associated with oil and gas exploration, production, processing, or treatment or transmission facilities. This will replace the 2021 EPA-issued National Pollutant Discharge Elimination System, MSGP, or TXR 0F000, which expires on February 28th of 2026. Also to implement House Bill 1688 from the 88th regular legislative session. This bill prohibits quarries located in the new Coke-Stevenson Scenic Riverway from obtaining stormwater coverage under the MSGP. The MSGP is being amended to prohibit quarries located in the new Coke-Stevenson Scenic Riverway from obtaining permit coverage under this general permit and to replace references to the John Graves Scenic Riverway with water quality protection areas within the general permit to encompass both the John Graves Scenic Riverway and the Coke-Stevenson Scenic Riverway. Public notice of the draft permit was published in the Houston Chronicle newspaper and the Texas Register on October 11th of 2024. The public comment period ended on November 11th, 2024 without any comments received. Staff recommends adoption of this general permit. Additionally, staff requests authorization to make non-substantive revisions to comply with Texas Register requirements. Thank you. We are available to answer any questions.
Thank you, Hannah. Any questions?
I do have a question. What is the typical schedule for us to update and renew our general permits in reference to, I hear the expiration date expected here next February. When would we have typically taken action to do this renewal versus, I understand it's a little earlier schedule because of the EPA delegation?
Yeah, so your question is for a normal renewal? For normal renewal for a stormwater permit, we start 2 years in advance. So we have already started the renewal process for the MSGP that expires August 14th of next year. So we have already started, and we're currently working on obtaining permission to send it to EPA for their review.
Wonderful. Appreciate that. Thank you.
It's a great question. Katerina? Nope. All right, hear from OPIC.
Good morning, Chairwoman, Commissioners, General Counsel, and Executive Directors, Attorney, and staff. For the record, I'm Pranjal Mehta on behalf of OPIC. Our office has reviewed the amendment to the TIPTES multi-sector general permit. OPIC understands that the amendment, without renewal, updates the permit to implement legislative changes from House Bills 1688 and 2771. Additionally, the amendment expands permit applicability to certain non-exempt oil and gas stormwater discharges. EPA has reviewed and approved the draft without requiring changes, and no public comments were received during the public comment period. Accordingly, OPIC supports adoption of the amended multi-sector general permit. Thank you.
Thank you very much.
And I'll just quickly note that no one registered for this item.
Thank you, Mayor. The proposed amendment without renewal of the stormwater multi-sector general permit incorporates oil and gas activities delegated to the agency in 2020, updates the permit to conform to the multi-sector general permit with EPA's 2021 multi-sector general permit, and makes other minor changes for clarification and consistency. I very much appreciate the stakeholder inclusion and involvement in this matter. I'd also note that no comments were received during the public comment period, and the EPA responded with an approval letter to proceed with the general public. Based on my review, I support moving forward with the adoption. Turn to my commissioners.
I agree.
I agree.
Thank you. Do we have a motion?
I move that we adopt the amendment without renewal of Texas Pollutant Discharge Elimination System General Permit Number TXR 050000 as recommended by the Executive Director.
I second.
All those in favor say aye.
Aye.
Aye. Motion passes. Thank you all very much. All right, item number 5, please.
Item 5 is the consideration of a resolution reauthorizing the delegation of authority to the ED to issue certain administrative orders and field citations, and increasing the administrative penalty threshold for delegation of this authority. The Executive Director's staff is here to present this item.
Good morning, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Sedemeyer of the Enforcement Division, and with me today are Christy Mills-Jurok with the Office of Compliance and Enforcement and Gitanjali Yadav of the Litigation Division. Pursuant to Texas Water Code Section 7.002, the Executive Director respectfully requests the Commission to expand the Executive Director's delegated authority to issue field citations and administrative enforcement orders by increasing the penalty amount from $7,500 to $12,500 or less. The current delegation authority of $7,500 or less has remained the same since 2011, even though certain changes have been made to increase overall penalties assessed through enforcement actions. Although there is no set ratio that has been set by previous commissions, the practical implication for many years was approximately 40% of all enforcement matters being considered and approved by the Commission on an annual basis. In evaluating current delegation authority, the Executive Director evaluated various thresholds and the potential impact to orders being considered by the Commission. Since 2011, there has been a shift of additional orders being considered by the Commission due to overall increases in penalty authority and other policy impacts that have driven an overall increase in penalties. Specifically, in 2011, the statutory maximum increased to $25,000 per day per violation. In addition, in 2021, the penalty policy increased the percentages in the environmental property and human health matrix and the programmatic penalty matrix. The nature of the orders being developed has not changed, simply our authority for our increased penalty structure. Given workload and ongoing division priorities, we are requesting the additional authority to align with prior posture as when the current threshold was initially implemented. We will continue to bring the most serious matters or any orders that may impact policy to the Commission for consideration, regardless of penalty, as outlined in the resolution.
Thank you, Amy. Any questions? Has anyone signed up?
No one is signed in on this.
OPIC?
Yes, good morning, Chairwoman, Commissioners, General Counsel, and the Executive Directors, attorneys, and staff. I'm Sheldon Wayne with the Office of Public Interest Counsel. Our office supports adoption of this resolution. The delegation of authority will serve both the regulated community and the general public well. We view increasing the penalty policy threshold as a common sense way of streamlining the enforcement process. It acts in furtherance of the Commission's goal of efficiently fulfilling its mission of protecting human health and the environment, while also preserving the public's ability to comment or otherwise participate in these enforcement matters. Thank you, and I'm available for any questions.
Thank you. Any questions for OPIC? Amy, 2011 was the last time this was revised.
There was a revision in 2016, but it was non-substantive and did not impact the penalty amount.
Okay, so substantive 2011.
2011.
All right.
Yes, ma'am.
My teenager was a 1-year-old at that time. He was a lot cuter then, tell you that. All right. Given the increase in the administrative penalty authority, as well as the adjustments to the penalty policy that have resulted in more robust penalties, I believe that it makes sense to make the corresponding increase to the ED's authority to issue enforcement orders. I'm prepared to adopt this proposed resolution. Colleagues?
Thank you, Chairwoman. I'm in agreement and want to thank OPIC again for naming the salient piece. In my mind, the pressure release valve of public participation is still available for all of the enforcement actions our agency engages in. And I remain confident that we will be able to elevate and act on orders as friction occurs in the future.
I'm in agreement.
Excellent. Thank you. Do we have a motion?
I move that we adopt the proposed resolution granting the executive director or her designee the authority to sign certain field citations and agreed orders in the amounts up to $12,500.
Second the motion.
All those in favor say aye.
Aye.
Motion passes. Thank you. All right, Mary, items 6 through 19.
That will take us to the enforcement docket. As you mentioned, 6 through 19. I would note that we have a request from the executive director to remand items 6 and 9 that is still pending. And the executive director is here to present these matters.
Good morning again, Chairwoman, Commissioners, General Counsel, and Public Interest Counsel. For the record, my name is Amy Sedemeyer of the Enforcement Division, and with me today are Christy Mills-Jurok of the Compliance and Enforcement Office and Gitanjali Yadav of the Litigation Division, representing the Executive Director. Pending before you are items 6 through 19. The total assessed administrative penalties are $163,495, with $13,837 deferred, $20,550 applied towards supplemental environmental projects, and $129,108 to the general revenue. The executive director additionally respectfully requests the remand of items 6 and 9 back to the executive director for further case development. For item 6, the respondent no longer owns the facility. Therefore, we would like to revise the order to reflect that correctly. For item 9, after further review during our preparation, we have determined that a different resolution path may be appropriate for this matter. We respectfully request approval of these items and are available to answer any questions you may have.
Thank you. Any questions?
Less a question, more. I was coming today prepared to grumble a little bit about item 9, and I'm really happy to hear that y'all are looking at it more closely. So I will withhold my grumbles. Thank you.
Glad we made your wish come true.
No grumbles here.
No grumbles. Do we have anyone signed up on any of these items?
On item 10, there's an individual who's available for questions, but didn't ask to address the commission. Otherwise, no one signed in on the enforcement docket.
Thank you. OPIC?
OPIC has reviewed each of these enforcement items. We would support remand of items 6 and 9, and otherwise we support adoption of all the orders presented by the ED staff.
Thank you, Garrett. I'd like to thank staff for their work to bring these items before us today. I understand that the ED has requested that we remand items 6 and 9 for further case development, and I'm happy to do that today. I reviewed the remainder of the items and I'm ready to move forward with them. Colleagues?
I'll only offer my observation. I'm grateful for the representative being present to answer questions on item 10. I'm not surprised to see that there's also a SEP participation included in that item. Both of those actions stand out to me as an indication of regulatory competence. So I'll just observe that. No comments.
I'm in agreement. No.
Is there a motion?
I move that we remand items 6 and 9 for further case development and adopt items 7 through 8 and 10 through 19 as requested by the executive director.
Second. All those in favor say aye.
Aye.
Aye. The motion passes. Thank you. Amy, your hair isn't pink anymore. Give everyone a second to move.
Brings us to item 20, which is the consideration for publication of and hearing on new subchapter K of 30 Texas Administrative Code, Chapter 101. This regards failure to attain fee for the 2008 8-hour ozone standard and corresponding revisions to the SIP. The executive director's staff is here to present this item.
Sorry about that. I'll start over. Good morning, Chairwoman, Commissioners, General Counsel, Public Interest Counsel. On behalf of the Executive Director, I am Jill Dickey-Hull with the Air Quality Division. With me today is John Minter of the Environmental Law Division. For your consideration today is item 20, the Executive Director's proposed rulemaking to create new 30 Texas Administrative Code, Chapter 101, General Air Quality Rules, Subchapter K, failure to attain fee for the 2008 8-hour ozone standard, and the corresponding revisions to the state implementation plan. The proposed rulemaking would establish the TCEQ Section 185 fee program for the 2008 8-hour ozone National Ambient Air Quality Standard, or NAAQS, as required by the Federal Clean Air Act, Section 182D3 and E, and Section 185. The fee program would be implemented in the Dallas-Fort Worth and Houston-Galveston-Brazoria 2008 ozone NAAQS severe non-attainment areas, should those areas fail to attain the standard by the July 20th, 2027 deadline, which will be based on 24, 25, and 26 air monitoring data. Staff respectfully recommends approval to propose publication of and hold a hearing on the proposed Chapter 101 General Air Quality Rules, and we are available to answer any questions. Thank you.
Any questions? Is anyone signed up on this item?
We do have an individual signed in to address the commission on this item, and we'll limit initial comments will be limited to 3 minutes per speaker for this item 1. We have Ms. Catherine Guerra here.
Hi, good morning, Chairwoman. Good morning, Commissioners. I'm Catherine Guerra with Public Citizen. The Commission's proposed Section 185 fee program, and specifically the alternative fee program, is a complex machination that accomplishes essentially nothing. It fails its only goal, which is to provide improvements to the air quality in the Dallas and Houston non-attainment areas that communities not only badly need, but that the Federal Clean Air Act requires. Congress established an act to protect public health, and the program is supposed to be a tool to bring severe and extreme non-attainment areas into compliance. Instead, the TCEQ is proposing a paper game, utilizing publicly funded TERP money from mobile sources of emissions to offset or prorate the penalties of private corporations and industry. Specifically, major stationary sources of NOx and VOCs in severe non-attainment areas in Texas. You're asking to have Texas drivers pay the fee owed by major industrial polluters. I believe, as others have commented, that the proposed alternative fee program violates the Clean Air Act directive and puts the state at risk for not only losing delegation of the program, but also the millions of dollars that TCEQ projects it could create and that could be reinvested into communities that are suffering from poor air quality. There are a number of other issues with the proposal, including the proposed basing of baseline emissions on aggregation of precursor emissions, which the EPA has already stated in its comments that it would not approve. And the TCEQ should also clearly define the attainment date consistent with EPA guidance so that proper fees are assessed for the appropriate periods of time and without any delay. Our state's air quality is not going to fix itself. We need the Commission to implement the Clean Air Act programs as Congress intended, and it's the position of Public Citizen, and we respectfully request that the TCEQ not proceed with this proposal and instead propose a Section 185 fee program as intended to assess and collect fees for major sources of NOx and VOC pollution and improve air quality and protect the communities where they're suffering from poor air quality. Thank you.
Thank you, Catherine. Is anyone else signed up on this item?
No one else has signed in.
Garrett?
OPIC has reviewed this project, and while we hope the fee program will ultimately be unnecessary, we also recognize that it is federally required. We appreciate the early opportunities for stakeholder inputs and understand that comments, both for and against certain recommendations, have already been received. OPIC will attend the public hearing, and we are interested to see and hear further public comments. At this time, we support publication of the proposal.
Thank you, Garrett. Well, before us is the proposed rulemaking to implement the required Federal Clean Air Act Section 185 fee program for severe and extreme 2008 8-hour ozone NAAQS non-attainment areas that have failed to attain at the applicable attainment date. These proposed new rules would establish the TCEQ Section 185 fee in Chapters 101, Subchapter K, failure to attain fee, and allow the TCEQ to retain these fees. The proposed rules include provisions relating to the applicability requirements, cessation of the program, exemption to the program, baseline amount determination options, fee assessment calculations, compliance schedules, collection, and payment. And I am looking forward to getting input from the public during this comment period. I'm sure it will be very robust. So I would move forward with approving the publication of these rules. Commissioners?
I look forward to reviewing public comment on this. Ready to move forward.
I appreciate the staff's work in crafting something flexible, and I look forward to the public comment as well.
Thank you. Is there a motion?
I move that we approve the publication of and hearing on new Chapter 101, Subchapter K, and corresponding revisions to the state implementation plan as recommended by the Executive Director.
A second.
All those in favor say aye.
Aye.
The motion passes. Give everyone a second. We'll move on to Items 21 through 24.
Items 21 through 24 are the consideration of the revocation of voluntary agreed orders with Southwestern Electric Power Company, Southwestern Public Service Company, Public Service Company of Oklahoma, and Texas Municipal Power Agency. The Executive Director staff is here to present these items.
Good morning, Commissioners, General Counsel, and Public Interest Counsel. My name is John Minter with the Environmental Law Division. Items 21 through 24 are 4 voluntary agreed orders for the companies and plants specified in the agenda captions for these items. These agreed orders were intended to establish federally enforceable particulate matter emission requirements. Since the Commission approved these orders and an accompanying proposed revision to the State Implementation Plan, or SIP, on July 29, 2020, the Gibbons Creek and H.W. Perky power plants shut down permanently, and the Oklo Union and Harrington power plants converted to burn natural gas instead of coal. The current owners of these power plants have requested that these agreed orders be terminated as they were no longer necessary to meet particulate matter requirements and should not be incorporated into the SIP. The ED respectfully requests that the Commission revoke the agreed orders for Public Service Company of Oklahoma, Oklo Union Power Station, the Southwestern Electric Power Company, H.W. Perky Power Plant, the Texas Municipal Power Agency Gibbons Creek Steam Electric Station, and the Southwestern Public Service Company Harrington Station, and direct the ED to notify the U.S. Environmental Protection Agency's regional administrator of these revocations. Thank you, and I am available for any questions.
Thank you, John. Any questions for the ED? Do we have anyone signed up on this?
No one has signed in on this item or any of these items.
Thank you. OPIC?
OPIC understands that these 4 power plants have permanently shut down and or converted from coal to natural gas. And as a result, their voluntary agreed orders are no longer needed. We therefore support revocation of the orders.
Thank you, Garrett. Item numbers 21 through 24 involve the revocation of agreed orders between the Commission and 4 coal-fired power plants. The current owners of these power plants have indicated that changes in operation or shutdown of their coal-fired electric generating units render their agreed orders moot. The H.W. Perky power plant ceased operating, no longer burns coal, and the coal units are being demolished. The Harrington Station converted its coal burning units to natural gas and ceased burning coal at all 3 units on January 1st, 2025. The Oklunian Power Station ceased operations, removed all equipment and emission sources associated with coal firing, and applied for and received an amended permit from TCEQ to modify the facility's existing boiler to fire with only natural gas, and the Gibbons Creek Steam Electric Station was sold in February 2021, and all air permits for the facility have been voided, reflecting the cessation of operations of the plant. Based on the terms of these agreed orders, I believe that it's appropriate to revoke them. Colleagues?
I'm in agreement.
I agree.
All right, do we have a motion?
I move that we revoke the Commission's voluntary agreed orders with Southwestern Electric Power Company, H.W. Perky Power Plant, Southwestern Public Service Company, Harrington Station, Public Service Company of Oklahoma, Oklo Union Power Station, and Texas Municipal Power Agency, Gibbons Creek Steam Electric Station, as recommended by the Executive Director.
Second. All those in favor say aye.
Aye.
The motion passes. Thank you. Thanks, John. Item number 25, please.
Item number 25 is our public comment session, and the Commission will receive comments from the public on matters within the jurisdiction of the TCEQ in accordance with Texas Water Code Section 5.112, except for pending permitting matters or other contested cases. These are subject to an ex parte prohibition found in the Texas Government Code Section 2001-061. In the interest of time, speakers will be limited to 3 minutes each, with a total time for public comment limited to 1 hour. Please note that the Commissioner's discussion of the subjects for which public notice has not been given are limited to statements of specific factual responses and recitation of existing policy. We have 1 person signed in virtually, Mr. Summerlin.
Mr. Summerlin, are you there?
Yes, can you hear me, Commissioner?
Yes, could you, just for the record, state your name and affiliation?
Yes, thank you. Good morning, Commissioners. My name is Errol Summerlin, and I'm co-founder of CAPE, the Coastal Alliance to Protect Our Environment. Over the years, I've had many occasions to talk to folks who live near what one Corpus Christi councilman refers to as Big Steel. I guess near is a relative term. What is considered near has always been a big question and is the one subject that dominates every protest against a Big Steel application for a permit. In my book, if you can see it, smell it, hear it, or feel it, that's near enough to recognize the impacts on public health and the peaceful enjoyment of residents' homes. And I wonder how often each of you get near one of these facilities. Do you visit them? Do you drive around some of the neighborhoods to see it, hear it, smell it, and feel it like the residents that endure it in every day and night? Many folks believe you live in and work in a bubble. You hear only the chatter of engineers, lawyers, and staff. Have you been up close to impacted neighborhoods in Deer Park, Port Arthur, Pasadena, Gregory, Refinery Row in Corpus, and Hell's Highway to Paradise between Portland and Aransas Pass? I want to share a recent exchange of about a dozen folks on social media, edited to delete reference to a particular facility. Similar conversations are held daily among neighbors and friends living in the shadows of these facilities. It goes like this. I'm on Granby and I heard a loud continuous rumble as in thunder, but at ground level, too loud for diesel. Concerning. Welcome to living in the industrial town. Flaring. It's the refinery. People on Portland Benson complaints are talking about it. It's been really loud. I'm off Memorial on Oak Ridge and felt it. Also very common. Well, I'm on Portland Drive and I heard it and felt it too. Had my headset on and was gaming online with friends and heard it over that. I just laughed it off and thought it was thunder. It's the refineries. Happens all the time that they flare. Yep, at my house, it seems like I'm living on a tarmac. The dog is so afraid he won't eat when it's happening, which sometimes is several days in a row. Just look north. You see the flare. If there's any northerly winds, it gets really loud and smelly at night. Just depends on how loud it is because of the amount of waste that needs to be burned off. When the ground flare is burning, I can hear the roar and my windows rattle. It's almost like the ground is shaking. It's the size of a football stadium. Commissioners, this kind of exchange occurs every day amongst neighbors and friends who live in the shadows of these communities. And I encourage you to burst out of that bubble. Visit with folks and hear more than just the legal and technical chatter at these meetings. Thank you very much for your time today.
Thank you, Mr. Summerlin. Are you based in Corpus?
I'm sorry again.
Are you based in Corpus?
Right now, I'm living in Maryland. I lived in Portland for 40 years and worked in Corpus Christi for those 40 years, but I had to move to the state of Maryland due to a battle with cancer of a family member. So I left my home of 40 years and I deeply regret it, but I'm still heavily involved in what's transpiring in what I consider to my hometown. Thank you for the question.
Yes, Katerina.
I appreciate the sentiment, and I know that we don't really know each other, and so you don't know how I grew up, but I did in fact live about 2 miles from the refineries in Pasadena, so I'm very familiar with the communities that you're referring to. Thank you.
Well said. Bobby, anything?
I don't have a response to Mr. Summerlin per se, but I do want to express gratitude for the comment and the sentiment. I think that's a concern that those of us who work and reside and focus so much of our attention in Austin is certainly well expressed. It's on my mind. I think that our agencies, regional offices, and our staff across the state give us a excellent firsthand perspective on the impacts and the real effects of living in and around and supporting the industries that we host in our state. That said, I'm grateful for your encouragement to us to get out of the bubble and to go visit these facilities. And I want to express an open invitation to you or other representatives of the public in that view to reach out to my office, reach out to ask us and invite us specifically. I'm eager to pursue that conversation. Thank you.
Thank you. And Mr. Summerlin, I will be in Corpus Christi on June 2nd. So I'm happy to meet with anyone in your organization. Just let me know. All right. Mary, next item.
The next items are for closed session, and the commission will meet in closed session in room 242 of the Texas Workforce Commission. Shall we say 1045?
Yes.
At 1045, as permitted by the Open Meetings Act, including Texas Government Code sections 551071 and 551074, to take up and consider matters pursuant to items numbered 26 through 29 as posted and noticed.
Thank all of y'all. This meeting stands in recess.
The commission met in closed session in room 242 of the Texas Workforce Commission from 10:52 a.m. until 11:27 a.m. on item number 26 as posted and noticed pursuant to Texas Government Code Section 551.074. No action was taken. This agenda stands adjourned and the time is 11:32.